Oh, boy. Is that him? Stephan McGee Stearns. He shaved his little stinking little head. Look, and what do you... Who would have thought, who had their money, who placed their bets that if he shaved his head underneath all that crappy little hair and that beard, his head was shaped like a root beer barrel? I knew it. I called it. I got one right around here. Hang on, we'll compare. Look at that noggin. Watch this. Look, there it is. That's exact. His head is shaped just like this root beer barrel. I knew it. There's something bigger and deeper going on here than we realize about these root beer barrels and why they're so important. Oh boy, it looks like he tried to keep little mutton chop sideburns too. What's up with that? Can y'all see that?
We're on the record, State of Florida versus Stephen Michael Stearns, 2024 CF 632. Appearance for the record, please.
Objection, Your Honor. The defendant looks like a doofus with that haircut. Can we take a recess and meet back when he grows it back?
Danielle Pennell and William J. for the state.
Alicia Smith and Alex Johnson on behalf of Mrs. Stephan Stearns.
Thank you. All right, the court has set this hearing on the defense's motion to continue the suppression hearing, which is currently set for tomorrow afternoon at 2 p.m. Defense, do you wish to present argument with respect to your motion?
Yes, Judge, and defense has a case. I provided a copy to the state already.
Okay. So tomorrow, on the 23rd, keep this in mind, people. We will meet back here about 2 p.m. He's got another court appearance, another hearing tomorrow.
You want me to give you a moment to read, Judge, or you want me to...
Just a moment.
Oh, gosh, look at him. Look at his stupid little mutton chops. You look like your name should be Thaddeus T. Herman. Oh, in the mirrors. He probably heard me say that. Oh, goodness. Oh, the years and the months have not been kind. He wears a 2X. Oh, wait. Is that a 2X? I'm looking at the back of his shirt collar. Is that a 2X or is that 28? Is he in cell 28? I got you. I got your address, brother. Cell 28. Oh, and he's got him a little thermal. Look at that. I can see from the material. He's got a thermal. They don't just hand those out, people. Mama and Papa bought that for him. Although it's getting a bit dingy. God, look at this guy. Look at the shape of this guy. I thought you said you were in there doing leg kicks and butterfly wheel, abdomen crunches and plyometric push-ups. What happened to that? As your mom would say, you look like a wad of chewed bubble gum. Show your face, Stephan. Show your stupid little face.
Do these highlight the McKay factors?
Essentially, Judge, they are essentially the same for the same
I'm
problem.
familiar with the McKay factors. Thank you.
And the cases that I provided to the court are Botham v. State, 272 Southern 3rd 876, a 50 CA case from 2019, Turner v. State, 311 Southern 3rd 185, a second DCA case from 2020, McKay versus State, first DCA, 504 Southern 2nd 1280 from 1986, and unpublished opinion that only has a Westlaw site so far, Surratt versus State, 2025, Westlaw 1119091 from last week from April of 2025. Trocola versus State, 867 Southern 2nd 129, 50 CA from 2004. And Singer versus State, 286 Southern 3rd 343, a 50 CA from 2019. Essentially, Judge, defense is moving to continue the motion to suppress the set for the afternoon, tomorrow afternoon, and looking at the...
So they want to postpone the hearing that's supposed to take place tomorrow. Ma'am, no. We've been waiting a long time to see this doofus. He done got his hair cut, a nice little haircut, and got all spiffy. Just as spiffy as he can be. So bring him in. He looks like if one of his Tamagotchis got a computer virus and just disconfigured and corrupted the little Tamagotchi pet. It's him. In his little cell. They should make Stephan Stern Tamagotchis that you can just throw, like press a button and it would just like throw a root beer barrel at it. Oh, hey, whoa, huh. Hey, cut that out, knock that off. That's what he would say.
The Bofo case, it essentially says that in moving for a continuance, defense just has to show that we haven't had a reasonable time to investigate or litigate the case. And that is balanced against the judicial economy and judicial efficiency. And
you've had plenty of time.
The McKay factors, as well as the factors that are listed in, I believe, Turner, that looks to a defense suffering an injustice by failing to grant the continuance, as well as if the delay was attributable to the defense or if it was unforeseen. Defense would argue that the intention is not to delay the court, isn't to be derelict in our duties. Defense is moving for this continuance based off of, as the court is aware, there is the second case, and preparing for the motion as well as in preparing the other case for trial. Defense is coming to information that at this time defense isn't in a position to be able to divulge to the court or in open court.
So your good cause is secret?
Essentially, Judge. Well, I can't in good faith.
Oh, we got a secret. We got a big old secret. We got a Stephan Stern secret. We got a SSS, people. Stephan Stern secret. How about that? It's a secret. Sir, no, absolutely not. What earlobe did you pull this crap out of, ma'am? A secret. Yeah, well, yeah, okay.
At this time, being that it's still being explored, I don't know which way it's going to go, if it's going to be something that's going to pan out in favor of defense or be able to be something to be utilized in this case. As the court is aware, a death notice has been filed in the second case, and while I'm not arguing specifically as to that case,
got a death notice.
This case is used as one of the aggravating factors. So a conviction on this case would be one of the aggravating factors the state would potentially be seeking in the death notice in terms of a homicide case. Defense would argue that this information has come to light recently, and we're still in the process of working through it and figuring out if it's something that would or wouldn't be available in this case. If the defense were to go forward with the motion to suppress at this point, potentially would be relitigated depending on the court's ruling on that. In terms of just regular pretrial in the case, we would continue the regular pretrial even aside from the motion to suppress hearing, because we did an evidence viewing. We were able to complete the evidence viewing, and the second part of that evidence viewing is scheduled for June 11th with the state in this case. So defense essentially is moving to continue balancing the Botham factors as well as the McKay factors. Defense believes that this isn't a unreasonable request on the court.
Oh, it's pretty unreasonable.
It's set for a hearing and still doing.
Your Honor, we're going to need you to be doing us a lot of favors due to the fact, well, you're not allowed to know what those facts are. It's a big secret, and you're not invited to the Cool Kids Club. The only way to get invited is to show us your Tamagotchi. If you don't have one, then you don't get that. You're not invited. You don't get to know. You don't get to know. Or you can buy your way in for a one-time fee of 10 root beer barrels. You know what's funny about the root beer barrels? I'm sorry. Gisela, because she was going to beat me up if I pronounced her name wrong again. From Grizzly True Crime, I heard her today. I tuned into her live for a little bit. And she was talking about the root beer barrels, and she said that she found paperwork. It's documented that he's not supposed to have them. Root beer barrels are restricted items, banned, I believe. So he's in jail running a root beer barrel operation, barrel smuggling, root beer running, the root beer musketeer. Guard your rear. Just thought That was interesting. Anyways.
Doing their due diligence in terms of preparing the case otherwise for trial and for the motion to suppress in and of itself.
All right. So the McKay factors, so we're on the same page, deal with a request to continue the trial. The other factors that you mentioned deal with a request to continue either a trial or a substantive hearing for absence of a critical witness. State response?
Yes,
Judge, do you need me to step in here? I can get my gavel. I can grab my gavel, Judge, if you need me. You let me know. And I got a nice wig for that head right there, that nugget. I got a nice wig for it.
Your Honor.
You just let me know, brother.
The state has not been in receipt of any witness list or any defense discovery in this case. The defendant in this case was arrested on February 29th of 2024. The public defender's office was appointed the next day at initial appearances. The discovery process started after the information was filed on March 11th of 2024. The state responded to the defense's demand for discovery on March 20th, 2024, and discovery has been ongoing. The motions to suppress that are currently set for hearing tomorrow were filed by the defense on February 6th of 2025. There was a motion to close the courtroom on February 28th of 2025. A notice of hearing for the closure of the courtroom was filed February 24th of 2025. Upon the denial of the defense's motion to close the courtroom on March 27th of 2025, the defense filed a notice of hearing for these motions to suppress. So these have been pending hearing since March 27th of 2025. The defense filed the motions to continue. The defense waited approximately almost 2 months, a little 2.5 months to request hearing time. The hearing has been set. The state filed responses to the defendant's motions to suppress on April 8th of 2025. And then I was contacted by defense. We had a discussion about their request to continue these hearings on April 10th, and a written motion to continue was filed on April 14th of 2025. The written motion filed by defense, the state's position is vague. It is unclear whether this information is necessary for a defense, is necessary for the hearing. The motion simply states that it may affect the presentation of evidence. The state has subpoenaed witnesses. We have a significant amount of hearing time scheduled for tomorrow afternoon. The state's prepared to proceed on the motions and is objecting to the motion to continue the suppression hearings.
Thank you. Any additional argument from the defense?
Yes, Judge. Defense will say that this is for the defense.
Yes, my client is not done with his haircut. He has not been properly lined up, as you can see. So we're not ready, Judge.
Even if the court were to ask ex parte in terms of, to have ex parte hearing in terms of the basis for the motion, I don't believe at this point defense will be able to disclose that information even to the court, even if an ex parte hearing were requested and or granted. It's defense's position that this information is necessary to be explored in terms of, it's necessary to be explored in terms of the presentation of the evidence.
I'm sorry. I know this is her job. Nothing personally against this lady, but every time she talks, all I hear is legal terms, but there's no like in between words that string together a full sentence. You say, well, in terms of the defense hearing and the practicality of the litigation of therefore, quote unquote, per se, ma'am, what do you want? Okay. And can you tell us the secret? I want to know secrets about Stephan. What's he doing in there?
Presentation of the case, because it's defense's position that at this time the information is confidential, which is why a witness list hasn't been disclosed. Discovery exhibits haven't been disclosed in regards to it because it's still being looked to and explored As the state indicated, discovery is ongoing, and as discovery has continued to be ongoing, so has defense's preparation of the case, reviewing of the motions, filing of the motions, preparation of the motion, as well as in preparing this case otherwise for trial alongside the homicide case. So it's defense's position that the granting of the continuance in this case would not be an undue burden on the court. I understand the state having subpoena witnesses. The day that I found out about the information was the same day we actually happened to have a position, so I spoke with the state in person about it, and then sent her an email in regards to her position, and then from there filed the motion to continue, and then we got hearing times while I was in trial with Your Honor as another case.
Can you imagine listening to this lady once it's time for her to present his entire legal defense during a trial? Oh my gosh. Well, per se said, quote unquote, status quo. Whoa, Nelly. Well, at that time, legally, the defense does maintain the right to remain silent, the Fifth Amendment, Declaration of Independence, and, and I rest my case. Oh boy, that's going to have to rewind that a few times to catch all that. Yes.
And I filed a notice of hearing as to that. Defense has been preparing, defense is preparing, and it's defense's position that denial of the motion to continue in this case would be an abuse of discretion, and we'd be asking the court to grant the request to continue.
Thanks. Well, the court's in a difficult position evaluating the McKay factors. In this case, the court's going to find that there has been significant time to prepare for these hearings. This case initiated in February of 2024. Motion was filed almost.
Speaking of hearings, Stephan's got great hearing. Look at them ears.
A year later, the matter was set for a hearing in March. 13 months. I'll note that this is on 24 CF 632. While the two cases are related, this does not deal with the homicide case. The court has an inability to make a determination as to the likelihood of prejudice from the denial. The defense apparently is in possession of some information, the nature of that information, the timing of when it was received, whether the defendant played any role in shortening the preparation time. The availability of that discovery is unknown to the court because the defense is unwilling at this point to share any information with the court, even on an ex parte basis, as to this information. Counsel that has been appointed to this case has.
I agree, Your Honor. I was going to also note the ex parte as well. It really all roads lead to ex parte at the end of the day. That's all I got to say. Now be on your way.
The requisite skill and experience to try this type of case. Both are either board certified criminal trial experts or in the process of becoming are being certified as a criminal trial expert. The court cannot, from the information presented, make a finding of a good cause, and while the defense.
Okay, and you're unable to make a finding of a good cause, but I bet you're also, unlike Stephan Stearns, unable to make a quality Quiznos sub with extra ham and lunch meat. Yeah, because you don't got the skills of Stephan Stearns. So that's two things you're unable to make in this courtroom, Your Honor. Take that. I rest my case. I turn it back over to you, prosecution.
Argues it will be prejudicial. There's been nothing advanced to the court to support that argument. So the defense's motion to continue the motion to suppress tomorrow, scheduled for 2 p.m., is denied.
Ha!
And I'll ask the state to please have their witnesses present and ready to go.
How about that?
No problem.
Thank you. Matter set for 3 hours tomorrow at 2 p.m.
Ooh, so we got 3 hours, 2 p.m. tomorrow, y'all. 3 hours. 3 hours looking at this doofus's head that looks like a shaved corn pop. Okay.
That will conclude our hearing.
That'll conclude it. Stand up, boy. Oh, look at him. Oh, my. Stand still. We want to see you. I want a good look at you. Look at him. He looks like he's got a root beer barrel in his cheek right now, slurping on it. Don't look so disappointed. Ooh. He's about to go back to his cell and call his mama. Yeah, well, well, yep, well, yep, well, you know, well, they looks like the judge denied the motion. You know, they know they're corrupt. They know that what they're doing isn't right, and you know, well, yep. Oh my goodness! Get on out of here before I do something to you. Get on out of here. Get out. Get your butt out of there. Get out of this courtroom now. Get out of this courtroom. Officers, frisk him for candy, for sucking candy. Frisk him. Yep. Look at that. Justice, the eagle. The eagle sees all. I see all you contraband root beer barrels in your cell, and I'm going to come get them. Great way to end this hearing, people. The golden eagle of justice. Coming down to snatch your little ears off your head. Stephan, tomorrow, be there. Meet me. Be there. Be square. I'll see you in the courtroom. Thanks for watching. I'll see y'all tomorrow.